Former President Donald Trump is closer than ever before to an historic federal indictment after special counsel Jack Smith's team told Trump's lawyers that their client is indeed a target in the classified documents investigation. Mr. Trump posting on social media Wednesday afternoon that, quote, "No one has told me I'm being indicted, and I shouldn't be because I've done nothing wrong." And joining me now is NBC Justice and Intelligence correspondent Ken Dilanian and former U.S. Attorney Paul Charton, Washington Post national security reporter Devlin Barrett, and former Homeland Security Secretary Jeh Johnson, also a former assistant U.S. attorney, a prosecutor here in the New York Southern District. So, Ken, today you're in Florida. Tell us why. We know why, but you tell all of us, why do the prosecutors? Does it make sense to take action in Florida versus D.C. on at least the Mar-a-Lago classified documents part of Jack Smith's investigation?
Right, Andrea. Good afternoon. What legal experts are telling us is that there are some technical legal issues that argue for what they call venue, where they're going to bring the case, being more logical in South Florida. It's obvious to everyone that most of the conduct at issue here, whether it's obstruction of justice alleged or mishandling of classified information or even dissemination, if he showed it to people, most of that conduct took place in Florida. But normally in the federal system, there's a lot of creative ways that prosecutors can bring a case in another jurisdiction. For example, the investigation is in Washington, D.C., so if the investigation was obstructed, generally you can bring an obstruction of justice case in the place where the investigation originated. But there's some quirky D.C. case law that makes that complicated in Washington in particular. There's also a pending Supreme Court case that really raises the stakes on getting venue wrong, suggesting that if you get venue wrong, it hasn't been decided yet, but it's possible that the rule could be you can't refile the case. The person gets off, essentially. So that really raised the stakes for where they bring this case and appears to make it more prudent that if they do file charges against Donald Trump, they file the bulk of them here in South Florida, even though they've been investigating for months in Washington, D.C. It really feels like there was a change at some point. Maybe some appellate lawyers inside DOJ said, hey, wait a second, it makes more sense to file in Florida. So that's where we are, and that's where we saw a senior member of Jack Smith's team walk into the courthouse this morning, Andrea.
And Paul Charton, there are critical questions just about how long any federal prosecution would last and the experience of the judge who might get the case. In fact, Florida would arguably, at least on the face of it, not be as favorable to the prosecution against Donald Trump, given the fact that the jury pool would have a lot more Trump supporters down there, that the judges down there don't have as much experience handling classified documents, and this could prolong a lot of the decisions over evidence.
That's right, Andrea. And if charges are brought in Florida, it shows that the prosecutors have a great deal of confidence in their case, as they should. Prosecutors have to have and know that they have a reasonable likelihood of success, proof beyond a reasonable doubt, to convince a unanimous jury that the defendant is guilty. And here, if prosecutors have made the decision that some or all of the charges relating to the classified documents will be brought in the Southern District of Florida, it means that they are confident that they have met each one of those standards and that they can meet those standards even in the face of judges who may be and have proven themselves already to be inclined to be favorable to former President Trump, or a jury pool that may be more receptive to hearing former President Trump's arguments. That would be much different and much more distinct than it would be in Washington, D.C. And remember, we're only talking about the potential charges that relate to the documents case. There are other cases relating to elections and the former and last election that may be coming or may be forthcoming, or that the grand jury in Washington, D.C. is looking at as well. So there's a possibility that you could have the grand jury in Washington, D.C. looking at one set of charges and a grand jury in the Southern District of Florida, Miami, looking at another set of charges.
But we did see, Jeh Johnson, as a former prosecutor, you saw what the feds went through in the immediate aftermath of the search, with all of the delays from that judge who was completely rejected by all the appeals courts. But it just prolonged the whole thing. And they don't have that much time right now, given that there's an election going on.
There is a political calendar at work here in the backdrop. It stays like this when my experience as a former federal prosecutor is more cred than having been Secretary of Homeland Security. So this case should be brought in the Southern District of Florida the weight of the venue is in the Southern District of Florida. The target is there, the documents were there, the discovery of the documents were there, the search was there, his home is there. I have seen criminal cases dismissed, including one I defended, for lack of venue. And if it occurs during the trial, double jeopardy might actually kick in. The challenge, in my view, and I'm sure Jack Smith's team is thinking this through, how do you get a panel of lay jurors to appreciate the serious compromise of national security if they can't see the classified documents? Do we pick a jury that can pass a security clearance? That's going to be an interesting challenge. Or do you redact the documents and somehow give them some amorphous description? I haven't seen too many cases where the issue at hand before the jury involves classified documents. So that's going to be a real issue here.
And if it goes to a judge, then they can do things in camera and make some decisions. But
yes,
if it's a jury trial, as this one will be.
Judges frequently do have security clearances, particularly judges in Washington, but there have been other cases across the country where the judge presiding on the case has to have a security clearance.
Devlin Barrett, I want to play what we heard from former Trump attorney Tim Parlatore, who famously resigned over disputes he said with Boris Epstein and the way the whole issue was being handled, the way the Trump legal team was being handled. But in terms of his interview with Lawrence O'Donnell last night on The Last Word, he raised the issue of prosecutorial misconduct and that they believed that they had grounds for dismissal on that. Let's watch.
Issues like misconduct committed by Jay Bratt and his team in bringing the case to this level. That is something that you want to consider, because you don't expect that Jay Bratt has informed Jack Smith and that Jack Smith has informed the DOJ superiors, oh, by the way, these are the things that we did wrong. So that's part of what we would present.
I think it's fair to assume that Jay Bratt has told them everything that he did.
I don't think that's fair.
So, Devlin, it's clear he's signaling that that's what the Trump team is planning to do.
Right. And that, to be honest, that is a legal strategy tailored to dealing with a special counsel, because the way the Justice Department regulations are written, the Attorney General can only overrule a special counsel decision on charging or important steps if they believe the special counsel hasn't followed DOJ practice. And so they are not in a situation where they can argue this is a weak case, that this is a case that shouldn't be brought. They have to argue that the DOJ did something wrong itself. And so that is a much higher legal threshold to reach in these arguments, and it's a long shot.
And, Jay, how damaging is this? You're also former general counsel at the Pentagon, among your many other top jobs. How damaging is this to our allies and our five closest allies, the Five Eyes, with whom we share everything, just about everything? We
ask that question when there is a compromise of national security, classified information. We ask that question after President Trump said what he said to the Russian foreign minister in the Oval Office. But we seem to always overcome those bumps in the road, in my experience. Our allies, I believe, continue to trust us. It certainly was true on my watch. And I think that will always be the case, given the strength of our intelligence community and the importance of information sharing among our allies.
Especially at a time of war, as it is right now.
Especially at a time of war.